Hello everyone and welcome back to my YouTube channel. On this channel, we share legal resources and information to help you know the law and understand your rights. On today's topic, I want to share with you how you can draft a contract in Nigeria. If you want to know more about this, you want to watch this video to the end, don't forget to subscribe and put on your notification bell so each time I post a video. Now, before you draft a contract, you want to know what a contract is. So in simple terms, a contract is a legally binding agreement between two parties or more that creates a legal obligation. So once a contract is signed, both parties or more are required to perform certain promises or certain rights or certain duties. For a contract to be legally binding, it must include certain elements. One of the most important elements that must be included in a contract or to make it legally binding is there must be an offer, there must be an acceptance, there must be an obligation, and authority or capacity to go into that contract. What I mean by that is when I say an offer or an acceptance, you see that when you are giving an employment letter, for example, there is always a column that says that if you accept this offer, you want to sign it and return a copy back. So any legal agreement must have an offer, it must have an acceptance, meaning that it must be accepted by the other party and there has to be a consideration involved. So there has to be an amount of money that is involved to make it a binding contract. First step in drafting a legal contract is to first identify the parties. You want to know who the parties are, you want to know their names, you want to know their addresses, and you also want to know their contact information. The next aspect is you want to clearly specify the terms of the contract. I like to say that this is the engine of a valid contract because this is where you clearly specify what the terms of the contract is. The first thing you need to clearly specify is the duration of the contract, how long the contract is supposed to last. So assuming the contract is for 6 months, you have to clearly specify it. If it is for 1 year, you have to clearly specify it. If it's for 3 years or even for less, you must clearly state the duration of the contract in the terms of the contract. Another aspect of this is you want to also state the consideration that is involved in the contract. So in the beginning of this video, I said that to make a contract valid, there has to be offer, acceptance, and then there has to be consideration. So if you are doing a valid contract, you want to take note of the consideration. So you want to clearly state the amount that is involved in that contract in the terms of the contract. Another thing is you want to clearly specify the role of each party to the contract. So you want to say the duties or the obligations of each party must be clearly stated, because assuming you want to go into a business contract or you want to go to an agreement to start a business together, you want to clearly state what the role of each party that is involved in the contract is so that it doesn't cause confusion in the long run. You also want to state how monies will be shared. So if you want to go to a business together, you have already put monies together to start that business, you have prepared the document. In that contract, you want to state, okay, assuming the business goes well, which everybody hopes for, if the business goes well, this is the amount that you will be paid every month. We have already satisfied that an employment agreement is also a contract. So when they give you an employment agreement, it is stated there how much you will be paid. It's always there, the consideration is there, and it is clearly specified the date you are meant to be paid and how much you are meant to be paid. So it needs to be there. And then in that particular category, you also want to state any other obligations or any other role or any other terms of the contract. Another aspect that needs to be clearly stated is the termination of the contract. So assuming the parties want to go their separate ways, it must be clearly stated in the contract. So we've already established that an employment agreement is a contract. So in some agreements, they normally state if you choose to leave the job, you must give at least 1 month's notice. It's like that in the contract. It needs to be clearly stated that assuming one party does no longer wants to continue, he can give 1 month's notice to the other party that he will no longer want to continue with the business or the contract. So it must be clearly stated. So assuming there is an act of God, what we call ultra virus, an act of God, there is a disaster or reasons that will make the parties unable to continue with the contract, it must be clearly stated in that contract. Another important aspect to include if you are drafting a contract is the dispute resolution clause. You want to make sure that you include a dispute resolution clause. Now, we don't hope that there will be disputes or disagreements, but you have to be prepared for the worst. So assuming there is disagreements or there are fights between the parties that are involved in the contract, you want to clearly state how those disputes will be resolved, either by mediation or by in-house counseling or by arbitration, or in worst case scenario, they may have to go to court to resolve their dispute, but it must be clearly stated. Okay, so another important aspect is that the contract must be signed and dated by both parties. So there has been an offer, there has to be an acceptance by the parties. After the parties have read through the contract, they agreed to the terms of the contract, it must be signed and dated. And I always say it, you have to include a provision for witnesses to also sign and date as well, because you never know what might happen in the future, and it is a valid contract, so it must be signed for it to be validated. So we have identified the parties to the contract, we have clearly specified the terms of the contract in regards to the duration, the termination, and the consideration as well. We have included the dispute resolution clause. It has been signed and it has been dated by the parties and their witnesses. The last stage in drafting a contract is to have the contract notarized by a notary public, or rather still by a commissioner for oaths in the court. That makes the contract valid and binding on all parties. So once the contract has been signed, it has been notarized by a notary public, the contract becomes binding, and all parties are now obligated to perform certain promises, certain duties, or certain rights that has been clearly specified. So we have come to the end of this video, and I hope this video was helpful to you. If it was helpful, you want to hit the subscription button, put on your notification bell, so each time I post a video, you get notified. Don't forget to give me a thumbs up if you enjoyed this video. If you have a question, you can leave it in the comment section so I can see it, and then I'll attend to your question. So until I see you guys next time, have a wonderful one.